This is your AP Government video for federal courts and judges. Article 3 of the Constitution covers the setup of the Supreme Court, and that's what we call our constitutional court. The Supreme Court justices are the ultimate arbiters and get to decide what the words in the Constitution mean and how they can be interpreted. Now, if you remember, Article 3 is fairly short. Congress also has the power to create inferior courts, anything that is lower than the Supreme Court, but that is under Article 1 of the Constitution, where it outlines the legislative branch. So constitutional courts include circuit court judges, which are the federal appeals courts, and district court judges, which are the very first trial courts in the federal system. Judges in all federal courts, Supreme Court justices, as well as appeals judges and district judges, all hold life terms. And remember, they are appointed by the president and confirmed by the Senate for life. We are going to be reading Federalist Number 78, which was written by Alexander Hamilton. And this is where they explain why they decided to give life terms to judges. The Supreme Court is independent from the other branches, other than the president being able to appoint a judge and the Senate being able to confirm. Other than that, they don't have a lot of regular daily interaction. The president and Congress work together really consistently in order to get bills passed. The Supreme Court and courts in general tend to be a little bit more removed from the politics part. And for obvious reasons, we don't want political partisanship to play a role in how justice gets served for different groups of people. This also helps the Supreme Court when they have to check and balance the president and Congress, which is part of their job. So district courts are the first trial courts in a federal case. And if you've ever watched something like Law and Order, then most of those are district courts, and they are tried by a judge and a jury if it is a criminal court. All of these in criminal cases use a grand jury. A grand jury is a large group of potential jurors, let's say 25 of them, and they're called in to hear what the prosecutor's arguments are. The prosecutor is the attorney that works for the government and is typically the lawyer who's trying to put somebody in jail. So they show their witnesses, they show their evidence to this potential grand jury, and based upon their feedback, decide if they think that's enough evidence to go to trial and possibly win. If so, then the prosecutor is going to issue an indictment. An indictment is a statement of charges, officially charging somebody with a crime. That's what starts the trial process. An indictment does not mean somebody's guilty. It just means that the government is going to go forward with a trial to try to prove them guilty. Once at trial, there is a petit jury, or sometimes called a trial jury. That is what you think of as a typical jury of 12 people plus 2 alternates, and they're the ones who decide the outcome of a criminal trial. Remember, the Fifth Amendment bans double jeopardy. So that means if you go to court and a decision is made in that trial, then a person cannot be retried for that exact same charge. This, of course, is different. If you've broken a state law and a federal law, then you can go to state court and federal court. And if there is, let's say, a hung jury, or for some reason they have to stop the trial and no decision was made, then they can restart a new one again. Circuit courts are federal appeals courts. So whoever loses the first trial has the ability to appeal. And circuit courts and appeals are not new trials with new evidence or new witnesses. It is basically the attorneys for each side going before a panel of 3 appeals judges. Those judges are looking over the previous court transcript to see if there was anything unfair about the trial. The court's whole purpose is to make sure that both sides have the right to say their case and that everything happened fairly. Nobody's rights were violated. You can't generally add in new evidence here. And in order to get an appeal, you have to prove that something was unfair. So for example, let's say you think there was witness tampering, or the judge didn't allow you to put evidence in the trial that you think would have proved that you were innocent, or you think that your lawyer was ineffective. those are things that you could argue in order to appeal. Of course, if the prosecutor loses, then the prosecutor can appeal. Circuit courts only hear appeals, so they never hear trials. And whoever loses the appeal can also reappeal. And in the second appeal, you just reappeal using a different set of 3 judges. Ultimately, you could keep reappealing over and over again until you've used up all of the judges in a particular circuit court. All right, for your active learning, I want you to answer these questions on a sheet of paper. Do you think that the Senate should take a nominee's political affiliation into account when they're confirming judges? Please explain why or why not. And 2, is it important that the judicial system is representative of the diversity of the population? And explain your answer.